And again, I understand Your Honor is not the government, but I think that is why the government, to their credit, did not make this argument, because that's well established in this court's cases.
To be fair, neither side made that argument, right? I mean, that's applicable. You instead appealed to the background rule that questions of law are for the court to decide de novo, right?
That's correct, but we think the inference...
Okay. Good enough.
Fair enough.
I wonder why you didn't make more of Elias-Zacarias. The court there said, and I take your point that the court there said the finding of causation could not be reviewed except as a finding of fact. But the court also said on page 481, it can be reversed only if the evidence presented by Elias-Zacarias was such that a reasonable fact finder would have to conclude that the requisite fear of persecution existed. That's kind of the traditional standard we apply when reviewing jury verdicts. We take the facts in the light most favorable to the victor, and we assess whether, as a matter of law, any reasonable fact finder could make the conclusion that the jury made. Elias-Zacarias seems to suggest the same standard, at least in this sentence, seems to suggest the same standard as applies under the INA. Is that your position?
No, we disagree with that, Your Honor, because again, that sentence you just read from Elias-Zacarias is correct as to what that case was about, this inquiry into causation, into the subjective state of mind of the persecutor and whether the non-citizen feared.
Why wouldn't we apply that same standard under the INA? So we take the facts, here they're undisputed, we take them as given, and we ask whether any reasonable fact finder could conclude that that was persecution as a matter of law. Why wouldn't that be if we're going to do de novo legal review, why wouldn't that be the standard we would apply?
Because, for example, I'll analogize this case to fair use or antitrust conspiracies, which often go to jury verdicts like it did in Google versus Oracle. In that instance, Your Honor is correct, the reviewing court would construe the record in favor of the verdict. But it would not then ask whether any reasonable fact finder could have reached the result rendered by the jury. It would review the determination de novo, and that's because the inquiry involved in those instances, despite being record intensive, you have to look at the particular facts of the case, as this court did at length in Google versus Oracle, for example. It's still a fundamentally legal inquiry, or at least a primarily legal inquiry under U.S. Bank. And we know that because, as again, decades of judicial experience.
Well, but the legal inquiry, again, with juries, it is a legal inquiry, but the inquiry is, as I've described it, it isn't, do we think this amounts to, on our own, that's usurping the fact-finding function, we say, of the jury. So we take all the evidence in light most favorable, and we say, could any reasonable jury conclude those facts are enough?
Respectfully, Your Honor, no, you do not do that in the fair use context, in the antitrust context, in Icicle Seafoods, where the question was whether the particular activities of a group of workers qualified them as seamen under the Fair Labor Standards Act.
I'm familiar with the antitrust context, and that's exactly how you review jury verdicts in antitrust cases.
The ultimate question of whether an antitrust conspiracy existed, whether there was anti-competitive conduct, that is ultimately reviewed de novo.
Viewed in light most favorable to jury verdict, could someone conclude this violates Section 2? Could this violate Section 1? That's exactly how we proceed.
I don't believe so, Your Honor. And Google versus Oracle, I mean, that's a decision from this court, held the exact opposite. It said, we do not ask whether any reasonable jury could find that there was fair use. We would determine, we're construing all of the subsidiary facts in favor of the verdict, but as to the ultimate question of whether those facts demonstrate fair use under the law, the court did not ask whether any reasonable jury could have found fair use. It asked, do we, exercising independent judgment, find fair use?
Why didn't you make that as a backup argument?
Because I think that's what the First Circuit essentially did in this case. It said, we're taking the facts as given and we're reviewing the BIA's interpretation of the law for reasonableness. That's the inquiry that we are asserting in this context is incorrect, because the underlying question is a primarily legal one that should be reviewed de novo by a reviewing court. That's why the BIA itself, I think under that reasoning, should be deferring to the IJ on this question. The IJ is the one who sat through the evidence. They've heard the testimony in the record. They're closest to the facts. That's an inquiry that under U.S. Bank would say, if this is a factual inquiry or a primarily factual inquiry, we should defer to the fact finder. The BIA does not do that. It recognizes that the inquiry is primarily legal and it warrants exercise of independent judgment by the BIA as the appellate body.
It's primarily legal. Go ahead.
Putting